So, thank you. My name is Chris Conley. I'm an attorney and technologist with the ACLU in Northern California. How many people know what the ACLU is? So, we're sometimes known as the EFF of the real world, but most of the time we are known as the nation's largest and oldest civil rights and civil liberties organization. We have over 500,000 members. We have affiliates representing all 50 states, District of Columbia, Puerto Rico, not Guam, sorry, but we represent all sorts of rights. So we have been increasingly focused on the world of technology and especially on the NSA because, as Rainey said, the technology is impacting all sorts of facets of our lives, and we find it incredibly important to recognize that even the more traditional ACLU rights of equality under the law and freedom from discrimination based on sexual orientation or health condition or everything else is dependent on how we relate to our technology. And so we have focused quite a bit of time and effort on working on government surveillance and other technologies that can erode our personal freedoms. So Rainey's covered a lot of ground, so I will fill in the gaps, and I will kind of take the high road and the low road. The high road, I want to talk a little bit about the Constitution and how that applies to the whole NSA situation. And then I want to go down low and talk about how the NSA's mentality has been filtering down to local law enforcement and how that plays into the whole surveillance equation. So the high road is the Constitution, and as Rainey said, there are multiple sources of law in the United States. Some of them are passed by Congress, but the fundamental law is the United States Constitution. And the Fourth Amendment gives people the right to be secure from, in their persons, sorry, I always forget this, persons, houses, papers, and effects against unreasonable searches and seizures. That is the fundamental privacy right under U.S. law. But what happens is that as the 200 plus years since the Constitution was written go by, courts have interpreted that to determine exactly what it means. How does it fit into the context of the modern world, which is very, very different from when the Bill of Rights was passed and the Constitution was signed. And they have, one of the fundamental changes in this law came in the 1970s. And there were a pair of cases called U.S. versus Miller and Smith versus Maryland that established what's known as the third-party doctrine. And this doctrine, put succinctly, says an individual does not have a reasonable expectation of privacy and therefore constitutional privacy protection in a record that is shared with a third party for business purposes. That has opened up an entire world of things because this was written again in the 1970s. This is not what a cell phone looked like in the 1970s. It came with a shoulder strap. It was a box. It had no location awareness. It was not able to send email or text messages or anything else. But the technology has radically changed since then, and the legal interpretation has not. It is starting to happen because of the NSA, because of other things, but technology is moving much, much faster than the courts and lawmakers can keep up with, which is why we have been engaged in so much advocacy around not just the law, but also technology, personal activism, democratic processes to try to address the situation, because we think it's fundamentally difficult for the law to ever keep up with the pace of technology. So I'm going to try to hit on the notes that I had and that I crossed out because Brittany talked about them. So one of the things that we focused on is indeed Section 215 of the Patriot Act, which allows the collection of business records, also broadly known as metadata. Metadata is not very well defined. There are lots of people using lots of different definitions, but generally speaking, it becomes all of these business records. Things like your location. When you carry around a cell phone, in order to receive calls, your cell phone has to communicate with local cell towers. That means those cell towers know when they saw your phone. If those records are available without constitutional protection, there are serious problems when you have government agencies who are eagerly sucking these up. It could include information about your use of the internet. Email. There have been arguments that the to and from lines of your email addresses are metadata, are not subject to constitutional protection. There's a whole wealth of things, so many that we actually wrote an entire paper about it. So I have lots of little postcards with the URL. I will leave it at that, but if you'd like to pick these up, you can learn more. We also are learning more and more that there are many, many different things that the NSA is not telling us. We know that Director of National Intelligence, Clapper, lied to Congress or misrepresented. He wasn't aware of all the ramifications. It wasn't intentional. It was just, it just happened that they were sucking up all sorts of things about American citizens.
He was thinking about something else.
His mind was somewhere else. But we also know that the NSA has frequently violated even its own internal rules, both in terms of how they use the information. There's an entire class of internal incidents called LoveInt, where NSA analysts have spied on their significant others using the technology. But there are also multiple indications that they are sharing information with other agencies. And then laundering the information so that no one can see where this information is coming from. So they'll share with the DEA information that they gain from national security purposes, with the understanding that DEA will then backtrack, use this information to find someone, but then come up with an alternate explanation for how they knew the person was there so they don't have to admit where they got the information because it violates the NSA's own rules. So what we're seeing is a system of safeguards and checks and balances that are being consistently ignored. And again, what we're also seeing, I'll move on to this because I know my time is going quickly, is the same mentality that is drifting not only from the NSA and from the federal government, but into local law enforcement as well. And we've seen this in a few specific technologies, and I'll name off a couple. The one that Max referred to that I was telling her about just before this is called Stingray. Does anyone know what a Stingray is in this context? All right, Rainey knows. Why am I the surprised guy? So, as I said, the way your cell phone works is that it has to connect to nearby cell towers. It essentially, as you're walking around and you're moving, it reaches out and says, hey, I'm here. Is there a cell phone near, is there a tower nearby? Because if so, if someone tries to call me, please pass my call on through you. That's how cell phones work. What a Stingray is a fake cell phone tower. Really, that's all it is. It acts like a cell phone tower. It will respond if a cell phone says, are there any towers nearby? What's your number? How can I register if I want to send a call? It will pretend to be a cell phone tower, but it's not. It is a device made by a company in Florida that is intended to track cell phones without even going through AT&T or Verizon or anyone else, even though they're very happy to cooperate. Sometimes even that seems to be too much. So this is pernicious in many ways because location can be used for all sorts of purposes. But one of our deepest concerns about this is it has been consistently and very intentionally clouded in as much secrecy as possible. Perhaps this would be funnier if it wasn't true. There was a recent case in Florida where two police officers came to someone's house, knocked on the door, were refused entry, forced their way in and searched the house without a search warrant. What came out in the ensuing court case is that they had used a Stingray to try to see if someone was inside the house. But then they signed a non-disclosure agreement with the company selling the Stingray, saying they wouldn't tell anyone about that, and interpreted that as meaning they didn't have to tell a judge why they knew the person was inside so they could get a search warrant. So completely undercutting the entire idea of transparency and checks and balances under the mentality of this is all secret because it's more effective if nobody knows what's going on. And we're seeing this in other cases too. We're also seeing more and more government agencies collecting, having the mentality of more data is good, we'll figure out the safeguards and the privacy consequences later, we're just going to expand our technology. Another topic I'll touch on there is the Domain Awareness Center in Oakland. Is everyone familiar with that particular story? So this is another trend which we're seeing, which is the Department of Homeland Security issues grants to local law enforcement agencies for all sorts of things. Berkeley somehow has a tank. I don't know why Berkeley has a tank, especially Berkeley having a tank.
That's right.
But Oakland applied for what they call the Domain Awareness Center. It was originally described as port security. They were going to use this to network together cameras in the port, to secure the premises, to have, to do a contained environment. And then someone got the idea, well, why don't we tie in everything in Oakland? We'll take the cameras in the streets, and we'll take our ALPR records, and we'll take everything, and we'll tie it all into this great Domain Awareness Center. They always come up with creepy names for these things, by the way. Domain Awareness Center, Total Information Awareness, there's so many, it's like, they need a PR person. But anyhow, the idea was, again, became something that, the scope just dramatically increased without any kind of, hey, wait, is this a good idea? What are we sucking in? How are we engaging with the public to have this? Now, fortunately, they had to engage with the public because they had to work with the city council. And the city council, because of advocacy from ACLU, EFS, many others, actually scaled it back to the original proposal, which was port security, and not let's know everything that's going on. But Oakland is not the only city thinking this way, and domain awareness and networking cameras together is not the only technology that people are pushing for this. There are more and more cities that are thinking more data is good. And in many cases they're right. Knowing things about traffic can help you build better roads. But tracking individual people can tell you who's attending a rally, or who's going to a clinic, or a job fair, or all sorts of very personal things. And so our role in the local arena has been very heavily on pushing for transparency, process, oversight, checks, and balances. Not to say that you don't ever think about using technology, but the idea should be you don't just simply roll out the technology first, tell people next, and figure out the safeguards later. That's the wrong approach. The first thing to do is assess the actual consequences of the technology, both good and bad. What purpose are you getting this technology for? how are you going to how is it going to actually serve that purpose? There's lots of evidence that, for example, cameras installed on streets are not terribly effective at fighting crime. They are expensive. They do not necessarily work. Sometimes they shuffle crime a little bit away. They can be effective at addressing certain kinds of crime. Acts of violence, they very rarely are because they're usually spontaneous and not based on, well, there's a camera there, so I'm going to beat up my partner. But anyhow, you have to assess whether something is actually valuable, as well as the cost to this technology. And that really means thinking about what kind of information is being collected, how could it be misused, what is it going to expose about people, how much is it going to cost to keep it and run it and train the people who need to manage the database, what are you going to do with it at the end of the day? And then actually go through the democratic process, which again is why I'm glad all of you are here, because it's really essential that this is not a decision made behind closed doors by the NSA or the FISC, the Foreign Intelligence Surveillance Court, or by local law enforcement or government. This needs to be something that has input from the community. And the community may well be very interested in having safer streets. The community should, that seems very reasonable. They may be interested in improving healthcare by understanding, medical trends better. But it also has real concerns about what happens when communities of religious groups are monitored. How does that erode the actual relationship between law enforcement and this group in a way that actually undermines the supposed protections that this technology or this practice is supposed to give? What are the consequences to freedom of expression if there are cameras in a public square and every time you want to go to a rally, whether it's a Shame on Feinstein rally or anything else, that's being recorded? And maybe your picture is being taken and facial recognition is applied and it's being matched with your driver's license photo. This kind of really changes the dynamic for public engagement. And therefore we need public engagement around whether or not and how we use these kind of technologies, around what kind of safeguards are in place before they're put into play, and around how we continue to evaluate and continue to think about this. Because, as I said, technology moves really, really quickly. And something that can do one thing today will be able to do 10 different things next week. Without really constant oversight, and that means vigilance by the community, as well as by organizations like ours and EFF, it's going to be really difficult for just one law that was written one day to keep up. And so that's kind of been my advocacy. Much of my work is around how can local communities really engage with their governments to make sure that local law enforcement is not playing into the mentality of we are the police. The government in a democracy is accountable to the people and not the other way around. And we think fundamentally that requires transparency, that requires input from the community, that requires the sorts of things that we don't see with the mentality of the NSA, which is it's all secret, just trust us. Because the ACLU notoriously, we're many things, but trusting of the government is not one of them. They do good things sometimes, but we don't take their word for it. I think with that I will end and turn it over to questions.